in addition to all her work at the university, and she's also worked politically. Most of us know Jocelyn as the candidate for Secretary of State about, what, 4 years ago? So she can speak not just as an expert in the field academically, but as somebody who knows what it's like to be a candidate and to deal with somebody who is, safe to say, was well-funded. I'll let Jocelyn, I'll let Jocelyn talk about issues of transparency and some of that too. But there's one other thing about Jocelyn that you should know. And I know this because she doesn't keep it a secret. She posted it on Facebook. She runs marathons. I don't know where she finds the time to do this. But, you know, I talked earlier about Joe Hill, and don't mourn, organize in terms of a response to McCutcheon. Well, let me also suggest that we're in a marathon. This is not a sprint. Jocelyn, the floor is yours. There will be a couple commentators, then we'll take questions and answers. But thank you for being here.
Thank you, everyone. Thank you. And I know we all know Stu and the incredible work he has done to put this together. But Stu, I just want to commend you as I mean, you're one of the champions in the States for these issues. You know firsthand how difficult, complex, and hard it is to really organize around this issue of transparency when we're all so busy and focused on other issues as well. But if you could just join me in recognizing Stu for all the hard work he's done. It's tireless, but it's critical. And so I think we are very, very fortunate that Stu Dowdy is here in Michigan and doing the incredible leadership work that he's doing on this issue. And it's great to see so many people here today on a very foggy, rainy day in Michigan, and eager to talk and collaborate about an issue that literally is ripped from the headlines. As we all know, the Supreme Court decided the McCutcheon case this week. I have an op-ed in today's Detroit Free Press about it. If you go online, I hope you can find it, depending on where it landed on their website. But in any event, I'll talk a little bit about McCutcheon today. But McCutcheon is nothing more. It is a terrible decision. It's a bad decision, but it's not a surprising decision. It's nothing more than not just a sequel to Citizens United, but the next step that our judiciary has taken away from the ideals of the founders of this democracy towards enabling a democracy that is run by a small group of people as opposed to the masses. And so the work that we all have ahead of us, and the work that is our duty, is to push back on that and ensure that we are continuing the work of the founding fathers of this democracy that created a government that is supposed to be of, by, and for the people. And there are many ways in which we can do that. And my only hope, my only ask is that none of you leave today feeling that there's nothing you can do. Because there's so much you can do. But not only that, you must do it. It is the only way. Those who have the power, those who are benefiting from the current plutocracy, have no reason to change it. But we all, as people in this democracy, know the need to change it. And so today is going to be about how we do that. And as Stu mentioned, it's not a sprint, it's a marathon, but it's a critical marathon for us all to engage in through, if we're going to ensure that our democracy actually survives and that our country thrives. So I want to start, I'm going to talk about the law and sort of lay the framework for where we are now. I'll close with some opportunities for change and just kind of give you a brief overview of what you're going to be talking about throughout the rest of the day on the various different avenues that we can go down together, all of which we must explore to actually push for more transparency in government, and in particular to solve the problem of money in politics. I have a little bit of a cold, so I apologize. So I'm going to start with showing you a campaign ad. A campaign ad that was at the heart of the Citizens United case.
Claiming basically the entire 8 years of the Clinton presidency.
This ad, I'll just say, brief introduction, this ad is an advertisement for a documentary that a nonprofit 501c3 organization called Citizens United played in primaries in states where there was a Democratic primary in 2008 during the primary phase of the presidential election. So this ad was run on DirecTV to advertise their documentary, which was available for purchase through the cable networks, and it ran just before the primary election in states facing a primary in the 2008 presidential campaign.
Is claiming basically the entire 8 years of the Clinton presidency as her own, except for the stuff that didn't work out, in which case she says she has nothing to do with it.
She makes herself sound like she has diplomatic experience, like she has managerial experience, as if she has policy development experience. She doesn't have any of those things.
She does not answer questions straight out.
I did not say that it should be done.
You said yes.
No.
You thought it made sense to do it.
No, I didn't, Chris, but the point is, what are we going to do with all these illegal immigrants?
Unless I missed something, Senator Clinton said two different things in the course of about 2 minutes.
She's driven by the power. She's driven to get the power. That is the driving force in her life.
She is steeped in controversy, steeped in sleaze. That's why they don't want us to look at her record.
Well, I think it's worth remembering, after her healthcare fiasco, the Clinton team put us aside.
I mean, certainly you have to ask whether she's learned a lot from that experience. It was a failure. She knows it was a failure. It was a very embarrassing failure for her.
She's a person who's struggling herself with figuring out who she is, or more importantly, how she wants to present herself to the American public.
She's deceitful. She'll make up any story, lie about anything, as long as it serves her purpose at the moment. And the American people are going to catch on to it.
I can't think of any other politician in history who has shown such a disrespect and a contempt for the Constitution and the rule of law as Hillary. And I represented Richard Nixon's best friend, and I knew Richard Nixon. And I'll tell you something, she's no Richard Nixon, she's worse.
Ruthless, vindictive,
Venal, sneaky,
ideological, intolerant.
liar is a good one.
Scares the hell out of me.
I am sick and tired of people who say that if you debate and you disagree with this administration, somehow you're not patriotic, and we should stand up and say, we are Americans and we have a right to debate and disagree with any administration.
So, that ad, so let me just ask you this. That ad played just in the days before voters are going to vote in a primary election between Hillary Clinton and Barack Obama. Oh, I'm sorry. So that ad, which was played in those primary states a few weeks before individuals were going to vote in a primary election between Barack Obama and Hillary Clinton. Let me ask you this question. Do you think that ad could be construed as a political ad? Perhaps informing / influencing / confusing voters about the issues at stake in a particular primary election?
Called electioneering.
Well, under federal law at the time, it was considered an electioneering ad, a campaign ad, and because the federal law, which I'll talk about in a minute, that defines campaign ads, which is the Bipartisan Campaign Finance Reform Act, also known as McCain-Feingold, passed in the early 2000s, says that a campaign ad is any ad that mentions a candidate close to an election in which they're going to appear on a federal candidate, close to an election in which they're going to appear on a ballot about 30 days or 60 days, depending on the general primary, and is distributed to a large audience. So it defines campaign ad just basically whether it mentions a candidate close to an election. Yes?
Being that people paid for it, it still falls in that category?
Yes. It does, because it's defined under federal law, under BICRA, Bipartisan Campaign Finance Reform Act, as basically if it mentions a candidate and it's played close to an election, then it's a campaign ad. Citizens United, Citizens United Corporation, 501c3, paid for this ad and to advertise their documentary, which they also paid for and had produced. And so their argument was, it's our First Amendment right to play this ad whenever we want to. We're just advertising our documentary. This isn't meant to or intended to, or I don't even know if they went that far with intent, but they simply just argued that this is an ad that they as an entity, a corporate entity, decided to play to advertise their corporate product. And for a federal law to say that they can't play it in certain states at certain times violated their First Amendment right. That brought the Citizens United case to the Supreme Court. And as we know, and I'm going to talk about, actually I'll go back to this. As we know, the court agreed with Citizens United in that case, said you're right, you have a First Amendment right as a corporation to play this ad whenever you want. And if the law defines it as a campaign ad in this instance, then that law is unconstitutional. So that case is known, Citizens United case is known for establishing this idea that money is speech, corporations are people, but both of those principles were already established long before the Citizens United case came to the Supreme Court. What the Citizens United case and the McCutcheon case also really most perniciously does is negate the concept that these types of ads or money in politics can corrupt politicians, voters, and politics. Because up until this point, evidence that money in politics would have a corrupting influence over a political arena was a justification for anything that could limit free speech. So there was at no point a real disagreement as to whether or not there was a First Amendment right for a corporation to put this ad on. The question was whether the government also had an opportunity and right to protect politics against corruption, and that right, the anti-corruption interest as it's called, would justify any infringement on a free speech right of a corporation seeking to play this ad. And the Supreme Court said in Citizens United, you know what, we don't think, slim majority of the justices said, that corruption is really a concern in the political arena with these types of ads. It's not corrupting politics, and therefore a government trying to stop this ad from being played cannot do so because there's really no evidence that these types of ads are causing corruption. So, yes.
A lot of people don't know that Thomas and Scalia were vetted at the Koch brothers.
Oh, yes.
Strategic planning meeting within 2 weeks of this rule.
Well, and there are a lot of backstories that we can talk about in terms of how justices reach a particular interpretation of the law and their influences. But I wanted to sort of start with that to give you a sense of really what the heart of what we're talking about is and how we got here, which is this idea that the court has, and this is emphasized in the McCutcheon case as well, the court or at least 5 justices on the Supreme Court. We don't want Justice Breyer and others who vigorously dissented against these viewpoints to be lumped together with the majority. But the majority, 5 justices currently on the Supreme Court have found or believe that corruption is in these cases not enough or not happening enough to actually justify infringements on free speech. So that's the heart of what where the disconnect is right now. And interestingly enough, corruption and preventing corruption, regulating money in politics to prevent corruption, to prevent buying off of politicians, to prevent the corruption of the marketplace of ideas in which we're supposed to be able to evaluate information and make informed, engaged decisions as voters. That interest, that governmental interest in preventing corruption of the political process has been really one of many reasons for regulating money in politics. There are others, but all of the others the U.S. Supreme Court has said, not enough of a reason to allow infringements on free speech. So the heart of the legal structure that we're in now is where, in order to have a regulation of money in politics that under the current constitutional interpretation withstands constitutional scrutiny, you have to be able to prove that because money equals speech under the Buckley versus Vallejo decision, which I'll talk about in a second, and because also corporations are considered people long-standing under various other precedents that I'll talk about. Because of those two things, the only way you can regulate money in politics is that if you essentially are doing so to prevent corruption, despite all of these other reasons why we need to regulate money in politics. One being promoting equality. We want equality in discourse. We want equal access to ideas. When one candidate has a great idea, but they can't get it out into the marketplace of ideas because they don't have enough money or resources to do so, or because someone else has a lot more money and is drowning them out, that harms the idea of having equal access to information and equal access to ideas in making informed decisions as voters. So if we only hear one side of a multi-sided argument, it's going to corrupt or it's going to thwart voters' understanding of what's really at stake in a particular election. And I come at all of this from the standpoint that the bedrock rule, not just of one person, one vote, which is critical in our democracy, but that for our democracy to thrive, we need to have engaged and informed citizens. For democracy to work, those who have the power to cast a vote and decide our leaders need to be engaged, they need to be participating, and they need to be informed. The other side of it is, once elected, our elected officials need to listen to those voters, which is, of course, what happens when voters are engaged and informed. They demand that accountability, so you need both, but you also need to ensure that when you call an elected representative, they're going to return your call not based on your bank account or how much money you've given them or have or can give them, but because you're their constituent and they work for you. So that's really at the heart of why regulation in politics is so critical, but of course, and that is sort of tied into corruption and promoting equality, but all those things, the Supreme Court has said, we recognize are important, but it's not really important enough to allow infringing on free speech unless there's actual evidence of corruption. So there's lots of different reasons that we're going to talk about today of all the different, and that many of you know that I have, some of which I have listed here to address money in politics. But preventing corruption has been the primary justification that the Supreme Court has found since the Buckley versus Vallejo decision in the 1970s, establishing that money is speech. Preventing corruption is the only justification the Supreme Court has found to be a reason to allow regulation of money in politics in the political arena. Real briefly, I like to start also by putting where we are today in the context with where we've been in the history of our democracy. We're entering, we all as advocates for regulation of money in politics are entering this arena now after literally a century's worth of work to regulate money. So the first century of our democracy, there was no regulation of money in politics in part. Does anyone want to venture why? Why from the late 1700s until about the 1900s? And also, no major corporations. Right, and it wasn't until the late 1800s that mass corporations really began. It's when you see antitrust laws begin to develop as well. But the industrial era of the late 1800s really paved the way for a recognition of the need to, once you had wealth generated through corporations in the United States, there was a need to, well, basically what happened was then corporate leaders started paying for people to run for office and bribing elected officials. And Teddy Roosevelt was the first national leader to be in an elected position, and in a message to Congress in 1905 said, enough, we need to ban corporations and banks from spending money in politics. So a Republican by the name of Teddy Roosevelt took the first step in regulating money in politics. And what was it? Not we need to limit contributions that individuals can make and all the rest. It was corporations and banks. That was the most pernicious influence of money in politics, and they passed the Tillman Act, which banned corporations and banks from spending any money in the political arena. It wasn't enforced. There were a lot of problems with it. And in addition to the fact that you were essentially asking those in the political arena to enforce this law, I mean, because think about it, who's going to enforce? It's people who are in who are elected to office, who are in the judiciary, who are appointed by individual politicians who are going to be enforcing this law and regulate, so it's a sort of self-regulation that creates an inherent conflict of interest that cause a lot of problems. And also, at the same time, corporations were like, you're going to stop us from participating. Well, what if we create a political action committee, which they did in 1944. Unions and corporations formed PACs for the first time as a way of circumventing the ban on corporations, and at that point unions, which had also grown in prominence, and the ban was extended to them in the 1930s. It's in an effort to still influence the political arena, corporations and unions created PACs so that members or employees could give money to a separate entity, and that separate entity, the PAC, would be run by the corporation or the union, and that PAC would give money to influence politicians and political issues. So that's how the PAC came about. It was really an effort to circumvent the ban. And that also illustrates that every time we've tried to regulate money in politics throughout history, money has found an alternative route to influence. And it's an important thing to recognize as we collectively think about what our vision is for and what's our ideal for the role that money should play, recognizing that as those who've come before us have asked and answered that same question, the other side has always found ways, loopholes and other ways, to circumvent. All of this really came to a head with Watergate in the 1970s. And for the first time, the federal government passed meaningful campaign finance reform known as the Federal Election Campaign Act. This act established the laws, most of which we know today. Individual limits on what people can give to candidates running for federal office, and limits on how much money PACs could give. It also included, at the time, a limit on how much candidates for federal office could spend when they ran elections. So there were contribution limits, expenditure limits. There were requirements that people disclose what they were raising when they ran for office. That whole disclosure requirement wasn't in place. They established through this act the Federal Elections Commission, the FEC, as a separate agency to actually enforce the law. So you're not asking those in the arena to enforce it. You're asking appointed commissioners to the FEC to enforce the law. And also established, the last thing it did was establish an option for public financing of presidential campaigns, which in some form is still in place today. That law was challenged as unconstitutional under the First Amendment in a case called Buckley versus Vallejo. And Buckley versus Vallejo established the base work for our entire constitutional framework around what is permissible and what is not permissible currently under the Constitution for regulating money in politics. This was the basic holding in Buckley versus Vallejo. It essentially did two things. One, it declared that money equals speech. Therefore, efforts to regulate money in the political arena are protected by the First Amendment, just as political speech is protected. What that means, again, is that once something is protected by the First Amendment, the government can only limit whatever is protected if they have a compelling interest in doing so. And so what the court said in Buckley versus Vallejo is, well, money equals speech, therefore money spent in the political arena is protected under the First Amendment, but if the government has a compelling government interest in preventing corruption or the appearance of corruption, then it is permissible for them to pass laws that will infringe on First Amendment rights because they're motivated out of an effort to limit corruption. So it created an avenue for regulation if you could prove to a court that the regulation's purpose was to prevent corruption or the appearance of corruption in the political arena. Under that framework, the court upheld disclosure requirements, which it always has. The court still to this day, Justice Kennedy has actually explicitly said in Citizens United that disclosure of money in politics is a critical interest. And so anyone who tells you that efforts to just simply disclose money in the political arena are unconstitutional, they don't know what they're talking about. And direct them to Justice Kennedy, Part 4 of Citizens United, where he explicitly says, disclosure's cool. Also says in Buckley versus Vallejo. They also upheld limits on individual contributions, recognizing that those were important to prevent the ability for people to basically buy off politicians. They upheld public financing if it's voluntary. So if someone voluntarily says, I want to, and we have this in Michigan too, have my campaign publicly financed, it's okay, but it can't be mandatory. Excuse me. And it also upheld the FEC idea. But they struck down limits on candidate expenditures, limits on what candidates can give to their own campaigns. So wealthy candidates who want to give millions of dollars to their own campaigns have a First Amendment right to do so under the idea, thank you, under the idea that, that someone can't corrupt themselves. So I'm not going to corrupt myself. Of course, there's always a question of how did you make all that money in the first place, and is that corrupting? There you go. It also struck down limits on independent expenditures. So if another entity, like a PAC, is spending money on a campaign but is not coordinated with the committee, that's an independent expenditure and you can't limit that. And finally, the court in Buckley said, well, at the end of the day, what we're regulating here is express advocacy, campaign commercials, for example. And so we have to delineate what those actually are. And what the court said in Buckley is that those are ads that contain the language, vote for, vote against, elect, or deny. So if an ad does not include that language, at this point, in this definition, it was not considered a campaign ad. If an ad is not considered a campaign ad, then it's just a commercial, and there's none of these requirements apply. Anyone can pay for it, all those things. So that's why the definition of what is a campaign ad is so important. And we're going to talk about that, I'm sure, throughout the day. The other point I just want to make is that this is a federal case evaluating federal law, so it only applied to candidates running for federal office. It did not apply to those running for state office. States and state laws regulate what the requirements are and the role of money is in state campaigns. So every state has its own regime, in addition to this federal regime of rules for money in politics. But the constitutional principles established in this case that I was talking about, free speech, corruption interest, all the rest, those do apply not just to the federal government, but to the states as well. And I just want to touch on Citizens United and McCutcheon. So you just saw the Hillary commercial a little bit earlier. Citizens United reversed limits on independent campaign expenditures by corporations and unions. So up until Citizens United, corporations were not allowed to take treasury money, their profits, and spend it on political ads, however they were defined under the law. And so as a result, most corporations would simply put money into a PAC, and the PAC would then pay for the ad. What Citizens United did was remove that requirement and allow corporations to directly fund ads. And it's important to note, I think, that what we've seen since Citizens United is that it's easier for corporations to spend money on ads. We removed some of the barriers, but we didn't, start from pre-Citizens United. We were still in a bad place. We still had a lot of corporate money in politics. We still had a lot of corporate money finding its way to fund ads in the political arena. Citizens United just made it much easier. The second major impact and the most problematic impact of Citizens United is this one right here. They reinforced the First Amendment protections that corporations have that were actually originated in a case in which the NAACP, or were reinforced in the 60s, when the NAACP wanted to march and protest. And the Supreme Court said, as a corporation, as an entity, they had a First Amendment right to march and to protest. So it's important to note that nonprofit corporations like the NAACP have also, were part of seeking and getting protections for First Amendment rights in past cases like this. And that's where the idea really emerged from that led to First Amendment protections formally being extended to corporations and reasserted as that in Citizens United. The second, in addition to the impact of more money in politics of Citizens United, the second, and in my view, the even worse impact of that decision was that the Supreme Court said that corruption is not a concern. That government trying to regulate corporate money in politics was not allowed to do so because there was no evidence before the court that corporate money corrupted politicians or the political process. That was and so much coverage of Citizens United didn't talk about that, but that part of the decision was really antithetical to everything we know about politics. And so the optimists out there, like myself, were like, well, maybe if we just prove to the court that corruption still exists, because the evidence out there, maybe they'll change their mind. And so a case came out of Montana about a year later in which the Montana Supreme Court was presented with actual evidence, bless you, that a law was passed in Montana to ban corporations from spending money, to giving money to politicians, and that law was passed because corporations were actually buying votes. And so there was evidence of corruption when the law was passed, therefore it should be okay. And the Supreme Court, when that case came up to the US Supreme Court, everyone was thinking, well, we've got evidence, it's in the record, now the Supreme Court will say as long as you show us evidence. No. Supreme Court didn't even clarify the fact that in this case there was evidence of corruption, actual evidence of corruption. They simply said, oh, Montana, maybe you should read Citizens United and apply it. That was it. So that is so the lasting impact of Citizens United also leads us to McCutcheon, which was decided this week, in which just in the same way, the court said that allowing individuals to give unlimited amounts of money to federal candidates also was not, there was no evidence that that would corrupt the political process. Therefore, any ban, in this case it was a ban on allowing people to give to lots of different candidates for federal office. Under the existing law that was challenged under McCutcheon, you can give a certain amount of money, I think it was $5,200, and no more, as one individual to a candidate committee. Now, folks like the Koch brothers would find other ways to give more money through PACs and others. So there were other ways to influence an election. But the most I could personally give to a presidential or candidate or senator candidate or congressional candidate was $5,200. And then I could only choose about 9 candidates across the board. There was a limit on how many candidates I could actually give that maximum amount to, the aggregate limit. And that aggregate limit meant I can only give to about 9 candidates. Why? Well, because if I can afford to, we don't want one person to essentially buy off the entire Congress. We want to actually limit how much impact they can have in that scenario. So what the Supreme Court said in McCutcheon was, no, that aggregate limit on how many people you can give to is unconstitutional, and because it violates your First Amendment rights, and there's no evidence that enabling you to give to 10, 11, 12 candidates would be corruption, it would corrupt the political process. So, just as an aside, 2 things on that. And I talk about this in my editorial in the Free Press today. 2 things on that. One, how many people can anyone in this room afford to give $48,000 or more, $50,000 or more in a particular election of federal candidates? No. I can't. You know who can? About 1,000 people in this country. So all this decision does is give those select group of people more opportunities to influence Congress and the Senate and the President, or really Congress. And just one second. Well, go ahead.
Just a quick question. You say 5,200.
Yeah.
But the report in the Times says it's 2,600. What's the difference?
Per primary in general. So I could give 2,600 in a primary and 2,600 in a general, and the collective amount is 5,200. Yes.
And the federal?
Yes. It only applies to federal candidates. Every state, remember, has different state laws. So what McCutcheon says, one, it's not going to, corruption, not really an interest, not really a problem. So it extends and relies on that most pernicious aspect of Citizens United, and that's why it's Citizens United too. But secondly, its benefit will only be to those who can actually afford to take advantage of it, which are a small number of people. And the reason why it is corruption to allow people to give to more candidates, let's say for Congress, is because if I can only give to 9 candidates for Congress, notwithstanding that there are other ways I can influence others' elections, if I can only give directly to 9 candidates, that means that I can't influence more than 9 members of Congress, which isn't enough necessarily to get legislation passed. But if I want a piece of legislation passed, I can now give to every single member on a committee, Democrats and Republicans, and ensure that my legislation gets passed. If that's not corruption, I don't know what is. So that's why the Supreme Court is stretching the boundaries of how we define corruption so extensively to benefit so few that though that sort of on its face you can say, oh, well, if I can give to 9 candidates, why can't I give to 10? Why are you stopping me? On its face, sure, makes sense, but underneath, it actually is a big step away from the whole reason why we have money in politics regulated in the first place, to stop a select few of people from influencing our elected representatives. So 2 last points, and then we'll move into a Q&A. The other thing I want to emphasize is that Michigan has a whole other regime here, laws and issues, and not much better than at the federal level. And I'm sure we'll talk about that more today, or we can talk about what Michigan has done or is doing in the state. I know you've got Rich Robinson here, many other people who are experts in that, and we'll be talking about that. So I just want to reemphasize that this is federal law we're talking about, but constitutional principles that apply to the states as well. The last thing I want to say is, what can we do from here? And I just want to emphasize, can you still hear me? I just want to emphasize that there are essentially there are many, many different reforms that we can advocate for, but 3 are most critical, and you need all 3. One is disclosure. If money is being spent to influence our political arena, we need to know about it. We need to know who is influencing our elected officials, who's trying to buy our votes, who's paying for those ads, because we deserve as voters to be informed if we're going to be engaged, and we require our elected officials to be responsive to us, not their highest bidder. Secondly, we need citizen-led financing of elections. Public financing, this gets back to the concept I was talking about earlier about, in my view, this is really not about banning anyone's speech. It's about equality and ensuring that everyone can influence their elected officials, just as we can all, presumably, be able to choose equally who represents us. So figuring out ways to engage more people in influencing our democracy through money is one of the challenges that a lot of folks are thinking and talking about today. In other words, how do we get more people how do we empower more people, not just to vote, but also to contribute money in a system where money matters to get your message out? And so one of the things that has been proposed, there's been many, and we'll be talking about them throughout the day. One of the things that's been proposed is giving everyone $100 to spend in an election. And everyone in the whole country can give $100 to whoever they want. If everyone in the whole country had $100 to give in addition to their vote to a politician, you think politicians might be a little bit more interested in aggregating not just their votes, but the money they have at their disposal to give? So we can talk a little bit more about that, but that's one of the other avenues that reformers are looking at. And then finally, I know you're going to talk about this more today, but amending the Constitution to overturn Buckley, Citizens United, and McCutcheon, and say money does not equal speech, or that nothing in the Constitution should be construed to provide and extend First Amendment protections to money. Thank you all for being here today. Thank you all for caring about this issue.
Let's give Jocelyn another hand. Thanks very much.